Welcome to the Advent IM presentation on effective employee monitoring. This presentation is designed to explore aspects of employee monitoring you may not have considered as actual monitoring, and to ensure that you understand your responsibilities in relation to information security for data generated by that monitoring, as well as underlining what you can and cannot do in the name of monitoring. And now, Mike Gillespie, Managing Director of Advent IM.
Some of the areas we will look at in this presentation include the reasons to start monitoring, the difference between snooping and monitoring or surveillance, how monitoring is affected by the Data Protection Act and the Associated Information Commissioner's Office guidelines, how to manage resulting data from various sources, sometimes generated for non-monitoring purposes, but from an employee perspective, still perceived as snooping. And we will also look at CIA, which is not what you might at first think. So there are a range of reasons HR departments decide to monitor employees, and a wide range of means with which to do it. Some of these areas may not have been considered monitoring, but are in fact just that, whether or not an organisation is acting upon the resulting data in a HR manner or not. Excessive use of phones for personal use, for example, or the monitoring of excessive use of internet for personal use, the monitoring of inappropriate behaviours in the workplace, or the misuse of company vehicles. Some of the reasons that monitoring is taking place, and these may be for corrective or disciplinary purposes. However, doing this incorrectly, or in a cavalier or ill-informed manner, is a minefield, and can be far more damaging for an employer than the actions of the employee who is being accused. But what is the difference between monitoring and snooping? A HR department's idea of acceptable monitoring may differ from an employee, particularly if that employee is facing some kind of disciplinary. Employees have a reasonable right to privacy, and in actual fact the ICO is very clear on the subject. Its guidelines say that monitoring must be approached with a spirit of honesty and openness towards employees. This means monitoring cannot take a blanket approach, just in case someone does something wrong. It cannot be covert. Employees must be made aware of any monitoring. It cannot take place if no policy or education of that policy has been given to employees. And all resulting data must be handled strictly within Data Protection Act articles. So what does this mean? Well, firstly, a spirit of openness towards employees. It sounds like you know exactly what it should mean, but it's worth exploring a little further. Not only do you have to ensure effective employees, and it must be affected employees as opposed to all employees, which would of course be snooping, are aware of the monitoring. You must also make sure that they understand why you are monitoring, and be totally clear on what the process is. Clearly, if this is going to be part of a disciplinary proceeding, it is vital that it is adhered to. They also should be told precisely what systems their employer will be monitoring. In other words, employees should be informed if their employer is monitoring their phone calls. They are also entitled to know who is responsible for the monitoring, and who will have access to the data generated by the monitoring. So for instance, if we use the phone usage example again, the employee should know who is recording the calls, and who will be permitted to listen to them. They are also entitled to know how the resulting data will be managed and eventually destroyed. So the employee should also know that their data will be stored securely in a passworded network area, accessible by the HR manager alone, and that it will be securely destroyed after the conclusion of the proceedings or after a reasonable passage of time. It is also vital to appreciate that without clear policies, education and policy enforcement, then the culture of the business will actually dictate the policy. In other words, what you actually do becomes your rules. If these areas are not addressed, employment tribunals may well result in a negative outcome for the business, and potentially could also attract the attention of the ICO, which is rarely pleasant. So let's look at some examples of handling data that has been collected on individuals during monitoring for disciplinary purposes. In our example here, consider the figure as being the IT manager. The data that has been collected on an individual in this example has been door entry data, timesheets, CCTV footage, tachograph data, internet activity, and recording of phone calls. Is it appropriate for the IT manager to collect this data? Let's put the question another way. It may be appropriate on a functional level for the IT manager to be collecting this data. However, in the spirit of the ICO guidelines, is it appropriate for the IT manager to be accessing the data once it has been collected? No, it isn't. And that is how the ICO would view it too. In this instance, if an employee who is potentially facing dismissal were to take this to a tribunal, there is every possibility it would be a negative outcome for the employer. The IT manager is not an appropriate person to be reviewing this information. More on this later. To make sense of how the situation should in fact be handled, we need to discuss CIA. Now that isn't the Central Intelligence Agency, although it is pretty intelligent. Or perhaps it's just common sense. CIA in this circumstance means confidentiality, integrity, and availability. These are vital components to building a successful and compliant monitoring policy. Limiting who accesses the data that is generated during monitoring means that there can be no breach of confidentiality. In our example, there is no reason why the IT manager should be able to hear phone calls made, or even see a list of calls. There is no reason why the IT manager should view timesheets outside of any normal timesheet sign-off for their own staff. Confidentiality also includes word of mouth. Imagine the repercussions if an employee is going through a dismissal and their colleagues have already found out what is happening. Authentic and complete data is very important. It sounds obvious, doesn't it? So data should be correct, of course, but can it be trusted and relied upon? For instance, if a document has been created and someone takes a copy of it, a newer version may exist which completely negates the content of the original. Version control is one way around this. If, as in this case, we are talking about a person's livelihood, it becomes even more vital that this aspect of security is strictly observed. Remember, all data to be acted upon for investigation purposes must be complete and as collected. Can the person who is supposed to be seeing this data see it, when and how they need to see it? Again, sounds obvious, doesn't it? Imagine, as in our hypothetical case here, the IT manager has saved a huge amount of data relating to our invented disciplinary case. However, the IT area of the network is not available to non-IT staff, and the IT manager has now gone on holiday to Portugal, leaving the key data for the monitoring safely hidden away and inaccessible for the disciplinary hearing. Point 1. The data is no longer accessible. Point 2. If someone else from IT were to access this data in order to help out management for the disciplinary hearing, we are compromising our confidentiality, the C, remember, in CIA. So again, the employee would have good cause for complaint. So let's look at our example again. Would it make more sense for the data to be accessed only by HR and pertinent management? Employees would also need to know who is accessing this data. IT will be involved in harvesting the data, but is it appropriate they have access to it? CIA is the guide to how you should manage this important and sensitive data. Don't forget, sometimes there are emotive issues involved, particularly in highly controversial or sensitive matters. So the person reviewing any resultant data needs to be in an appropriate setting. For instance, if someone is habitually surfing on pornographic websites, and data is collected on what they are viewing, it is not appropriate for the offensive material to be reviewed in a busy office, potentially surrounded by the people who would have been offended by it in the first place. Also, they should be aware of the correct procedures, as for instance in this example, not making copies of everything that has been viewed, as this in itself is also an offence, especially if it's something like child abuse, etc. Remember, the ICO is clear on what is acceptable, and CIA provides an excellent framework to hang the process on. It may well be appropriate for someone to collect the data, but not necessarily to be permitted to access it. If you want to read more about the ICO guidelines on employee monitoring, you can find it in the place indicated on screen now. Here you will find the quick guide for employers, which is useful for any organisation, but may be particularly helpful for smaller and enterprise-sized businesses. To summarise then, always use the ICO guidance. When monitoring, have firm, clear objectives and targets in mind. Be open and consistent with all of your staff, and ensure that all resultant data is appropriately managed in line with the Data Protection Act.
We hope you enjoyed this presentation, and we also hope that you'll come and visit us. You can find us at www.advent-im.co.uk. And don't forget to come and have a look at our blog. You can also find us on LinkedIn and on Twitter.